Thank you for the opportunity to appear and speak about the scope of congressional power to protect voting rights. The Supreme Court held that the coverage formula of Section 4B of the Voting Rights Act was unconstitutional. This has created substantial confusion about the level of deference that the court should accord to Congress when reviewing the legislative record of any federal voting rights legislation.
She's written a wide range of topics in the field of election law, including partisan gerrymandering, campaign finance reform, the Voting Rights Act of '65, and the Reconstruction Amendments.
Congress's authority under the Elections Clause is, in the words of the Supreme Court, paramount. The Elections Clause has been overlooked as a source of authority for the Voting Rights Act of 1965, even though the clause provides additional authorization for its provisions. In addition to its power to enforce the guarantees of the 14th and 15th Amendments, which prohibit racial discrimination in voting and elections, the Elections Clause of Article 1, Section 4 provides that the states shall choose, quote, the times, places, and manner of holding elections for representatives and senators, but subject to Congress's authority to, quote, make or alter such regulation. This provision forms the basis of our system of federal elections by giving states plenary authority to set the ground rules while Congress retains a veto power over state regulations. By depriving states of the final policymaking authority that is the hallmark of sovereignty, the clause is impervious to the federalism concerns that have constrained congressional action under the 14th and 15th Amendments.